We are in February 2026, and the legal ground beneath American gun ownership just shifted in ways that most gun owners, and virtually all of the mainstream media, haven't fully processed yet. A federal appeals court ruling has handed down 10 changes to how gun laws work in this country, and these aren't minor technical adjustments at the margins. These are structural, foundational upheavals that affect how you carry, how you store, how you transport, how you defend your home, and how the government is legally permitted to treat you when you exercise a constitutional right. 10 massive changes. Some of them hand you freedoms you've never had in your adult lifetime. Others close traps that have been financially and legally destroying good people for years. And the politicians, bureaucrats, and state officials whose power depended on the old system are counting on you staying uninformed long enough for them to find their next workaround. That ends right here. If you own a firearm in America and you haven't heard about these 10 changes yet, subscribe right now, hit the notification bell, and pay close attention. Because the gap between knowing this and not knowing it is the gap between exercising your rights with confidence and walking into a legal disaster you never saw coming. To understand why this ruling lands differently than what came before, you have to understand the playbook that anti-gun states have been running for the past decade. After the Supreme Court's major Second Amendment decisions made outright bans constitutionally untenable, the strategy shifted. It became death by bureaucracy, death by delay, death by creative redefinition. If you can't ban the right, you make it practically inaccessible. You make permitting so slow and so subjective that people give up. You declare everywhere a sensitive place so the right has nowhere to actually be exercised. You use regulatory inspections to destroy the businesses that sell firearms. You maintain databases you have no legal authority to maintain. You write storage laws that render firearms useless the one time they actually matter. It has been a coordinated, multi-front campaign to achieve through administrative obstruction what couldn't be achieved through outright prohibition. And it worked. For years it worked. Because the courts weren't applying a rigorous enough standard to see through it. That changes now. This ruling doesn't just address individual provisions, it dismantles the underlying strategy. And that is why it is different. That is why it matters more than anything that has come before it in recent memory. The first change is the constitutional foundation that makes everything else in this ruling possible. And it is the shift that state attorneys general and government legal teams across the country have been most dreading. For decades, for generations, really, courts applied a relatively permissive standard when reviewing gun restrictions. The government essentially had to show that a restriction was reasonably related to a legitimate government interest. That sounds serious until you realize how easy it was to satisfy in practice. Almost anything qualifies as a legitimate interest. Almost any restriction could be described as reasonably related to it. The bar was low enough that thousands of laws with dubious constitutional foundations cleared it without difficulty, and gun owners had no practical recourse. This ruling changes the standard to strict scrutiny, the most demanding legal test in American constitutional law, and makes it mandatory for every gun restriction, without exception. Under strict scrutiny, the government must prove a compelling interest, not just a legitimate one. It must prove the restriction is the most narrowly tailored possible means of achieving that interest, meaning it cannot sweep up law-abiding citizens in regulations designed for bad actors. And it bears that burden of proof entirely, not the gun owner. The implications are staggering. Thousands of laws that coasted through under the old standard are now legally vulnerable under the new one. State and local governments know this, and they are currently conducting internal reviews of their entire gun regulatory frameworks, trying to identify what survives and what doesn't. The answer, in many jurisdictions, is not much. The second change follows directly from the first and addresses one of the most persistent and perverse injustices in American firearms law, the reality that successfully defending your life with a gun used to be the beginning of your legal ordeal, not the end of it. A man in Ohio shot a burglar who broke into his home at 2 in the morning. No criminal charges were filed because the shooting was clearly justified. The burglar's family filed a civil lawsuit anyway and extracted a $400,000 judgment that financially devastated the homeowner. A woman in California fought off a violent attacker in a parking lot, survived the assault, and was then sued for $1.2 million by the person who tried to hurt her, on the theory that she used excessive force in her own defense. This ruling creates a civil immunity shield for lawful self-defense. If your actions satisfy the legal standard for justified self-defense, the person who attacked you, or their family, cannot bring a civil lawsuit for injuries sustained during that attack. Anyone attempting to sue must prove your actions were criminal before a civil case can even be heard. The burden is entirely on the plaintiff. This single change removes one of the most effective psychological weapons that existed against lawful gun ownership: the knowledge that even a clean, justified defensive shooting could destroy you financially through civil litigation. Right now, I want to stop and ask you to do something specific. If you know a gun owner, a neighbor, a family member, someone at your range, who is still operating under the old rules because nobody told them these 10 changes happened, share this with them right now. And if you haven't subscribed yet, this is the moment. Because we are only getting started, and the next 8 changes are where it gets even more consequential. The third change shatters a legal protection that has allowed law enforcement officers to violate your Second Amendment rights for years without any meaningful personal accountability. Qualified immunity has been one of the most controversial doctrines in modern American law, a judicially created shield that protected officers from civil liability even when they clearly violated someone's constitutional rights, as long as the right wasn't clearly established in prior case law. In practice, this created a circular problem. Rights couldn't be clearly established without cases, and cases couldn't succeed because rights weren't clearly established. For gun owners, this meant that an officer who confiscated your legally owned, legally carried firearm during a traffic stop faced essentially no personal consequences, even if the confiscation was obviously unlawful. This ruling removes that shield specifically for Second Amendment violations. When an officer violates your clearly established gun rights, when they take your legally owned firearm without probable cause, when they treat your valid carry permit as worthless, they face personal financial liability, not departmental liability. Personal. Last month in Virginia, an officer stopped a man, discovered he was carrying a concealed handgun, and confiscated the weapon despite the fact that the man had a valid permit and had disclosed it properly exactly as required. The officer lost a $300,000 personal judgment. That number and the personal nature of it changes how individual officers approach these interactions. It introduces a consequence that didn't exist before. The fourth change addresses the most sophisticated workaround that anti-gun states developed in the aftermath of the Bruin decision, and it is the one that reveals most clearly how far certain state governments were willing to go to nullify a constitutional right they disagreed with. When outright carry bans became constitutionally indefensible, states pivoted to sensitive place designations. The legal theory was that while you have a right to carry in public generally, certain locations are sensitive enough to warrant restrictions. And then the project became to define sensitive as broadly as possible. Some states produced lists exceeding 50 categories of prohibited locations: airports, parks, restaurants, transit stations, hotel lobbies, sidewalks near schools, sidewalks near government buildings. In some jurisdictions, the math worked out to the government having designated more than 90% of publicly accessible space as off-limits, which is a carry ban with extra steps. This ruling imposes a strict 2-part test. A location qualifies as a sensitive place only if it has actual physical security infrastructure, metal detectors, armed security personnel, access screening, and only if there is a genuine historical basis for restricting firearms in that type of location. A courthouse with metal detectors and armed marshals passes the test. A school with security screening and officers passes. A public park with a sign that says no guns absolutely does not pass, and neither does a restaurant, a transit platform, or a hotel. States are being forced to reduce their sensitive place lists by 80% or more. The constitutional right to carry is being restored to the places where ordinary Americans actually live their lives. The fifth change targets the bureaucratic delay tactic that was perhaps the most elegant form of rights suppression ever devised, because it required no legal justification whatsoever, just the ability to ignore paperwork. In New York, carry permit applications were sitting for an average of 18 months before receiving any response. Applicants would submit their materials, pay their fees, and wait, and wait. Requests for additional documents would arrive months into the process, restarting timelines. People changed jobs, moved addresses, gave up. The system was designed to wear people down through sheer frustration, and it worked. This ruling mandates that every state must approve or deny a carry permit application within 60 days of submission. If the state fails to act within that window, the permit is automatically approved by default. States cannot request additional documentation after submission unless they identify a specific written legal deficiency. The clock starts when the application arrives and does not stop. Denials must come with detailed written explanations citing specific legal grounds, not vague judgments about character or subjective assessments of need. Multiple states are already reporting that they have approved more carry permits in the past 3 weeks than they processed in the previous 6 months combined. That's what happens when you remove the government's ability to weaponize delay as a substitute for constitutional compliance. The sixth change addresses something that required a level of cynical creativity to design: storage laws specifically engineered to make firearms useless in an actual emergency. Massachusetts required ammunition to be stored in a separate locked container completely apart from any firearm. California mandated ammo be kept in a different room. A county in Illinois required firearms and ammunition to be stored on different floors of the same home. The stated rationale was always safety, but the actual effect was to ensure that in the event of a genuine emergency, a home defender would need to travel to multiple locations within their own house, unlock multiple secure containers, locate and retrieve ammunition, load the weapon, and then respond to the threat. The ruling states that storage mandates that prevent immediate access to a functional firearm violate the Second Amendment because they render the firearm constitutionally useless. A gun you cannot access in time is not a gun for purposes of the self-defense right the Second Amendment protects. You have the right to store your firearm and ammunition in whatever configuration you determine best serves your ability to defend yourself and your family. The government's authority over how you organize your own home for the purpose of degrading your ability to exercise a constitutional right is gone. The seventh change is the one that should generate the most genuine public outrage because it involves state governments operating in direct, documented violation of federal law for years and facing no consequences until now. Federal law has explicitly prohibited a national firearms registry since 1986. The prohibition is not ambiguous. It is illegal for any government entity to maintain a system that tracks which specific firearms are owned by which specific Americans. States knew this, and they built registries anyway, wrapped in different names and administrative frameworks. California's dealer record of sale system had accumulated records on 20 million handgun purchases going back to 1996, 20 million individual transactions linking specific people to specific firearms. Hawaii required every gun in the state to be registered with local police, complete with make, model, serial number, and the owner's full personal information. These were functional gun registries operating in direct defiance of federal law, and the agencies running them were not unaware of that. This ruling names them, orders them dismantled, and sets a 180-day deadline for complete destruction of all records. Every state that maintained these illegal databases is required to send written confirmation to affected gun owners that their personal information has been permanently deleted. States are challenging the order, and the court's response was explicit. Non-compliance means contempt charges and escalating daily fines until the registries are gone. The government spent decades illegally collecting this data. Now they have to destroy it. The eighth change closes a regulatory weapon that the ATF has wielded against the legal firearms industry for years, and its misuse has been so brazen and so well documented that the court had no difficulty identifying it for what it was. Federal firearms licensees, gun dealers, manufacturers, importers operate under a mountain of regulatory requirements and paperwork obligations. Compliance is genuinely complex, and honest administrative errors in complex systems are inevitable. The ATF had been treating those inevitable errors as grounds for license revocation, sending inspectors not to ensure compliance, but to find the clerical mistake that would justify shutting a business down. A gun store in Pennsylvania lost its license because the owner wrote the wrong year on a single form. A Texas dealer had his entire livelihood revoked for using blue ink instead of black ink on transfer documents. These were not criminal enterprises. They were small business owners making honest mistakes in a system designed to generate opportunities for enforcement. The ruling ends this: the ATF can only revoke a federal firearms license for an actual criminal violation of law. Administrative errors require a written warning and a reasonable opportunity to correct. The regulatory apparatus can no longer function as a covert mechanism for eliminating firearms businesses that someone in the agency has decided should not exist. The ninth change is the one that millions of Americans who travel for work, family, or any other purpose have been waiting years to see. Concealed carry reciprocity has been a patchwork nightmare for as long as meaningful carry rights have existed. You could hold a valid, carefully obtained carry permit from your home state and become a criminal the moment you crossed an invisible line into a neighboring state that didn't recognize it. People were arrested at traffic stops 20 miles from home because they hadn't checked, or had checked and found outdated information, about whether their permit was valid in the state they'd briefly entered. This ruling establishes a national recognition baseline. Any valid carry permit issued by any state in the country must be honored in at least 42 states. Your permit is your permit. It doesn't evaporate when you cross a state line. States cannot impose additional requirements on out-of-state permit holders. If your permit satisfies your home state's standards, it satisfies the recognition requirement in all 42 states now obligated to honor it. Law enforcement agencies in states that previously refused to recognize out-of-state permits are being retrained right now in February 2026 to handle interactions with visiting permit holders appropriately. The days of the legal Russian roulette that came with driving across the country while legally armed are ending. The 10th change is the most emotionally resonant one, and the injustice it corrects is so fundamental that it's difficult to articulate how thoroughly it betrayed the people it victimized. In certain jurisdictions, surviving a violent home invasion was the beginning, not the end, of your ordeal. District attorneys, elected officials making political calculations, would pursue criminal charges against homeowners who had used legally owned firearms to defend themselves and their families, even in cases that were by any reasonable standard clear-cut justified self-defense. A homeowner who shot an intruder armed with a crowbar, a man with a documented history of violent crime, was arrested at his own front door, charged with aggravated assault, and spent 2 years and every resource he had fighting the case before being acquitted. A woman in Maryland shot an ex-boyfriend who had kicked in her front door in direct violation of an active restraining order. She was arrested, charged with attempted murder, and spent 8 months in jail before the case collapsed. These prosecutions were not mistakes. They were a strategy. Make defense of your home legally and financially catastrophic enough, and you change the calculation gun owners make. This ruling shifts the burden of proof in home defense cases entirely onto the prosecution. If you use a firearm to defend yourself in your home or on your property, prosecutors must prove beyond a reasonable doubt that your actions were not justified self-defense. The burden is on them, not on you. That is how it should have always been. Here is what these 10 changes mean when you stop looking at them individually and see them together as a system. Because that's what they are, a response to a system. The anti-gun strategy of the past 2 decades wasn't built on any single law or any single tactic. It was an ecosystem of incremental suppression. Make the permitting slow, make the sensitive places everywhere, make the storage rules render guns useless, make the registries track everyone, make the ATF destroy compliant businesses, make the civil courts finish off anyone who survived a justified shooting. Every element reinforced every other element. Every piece of the system made the whole harder to dismantle. This ruling tears into the entire ecosystem simultaneously. It restores strict scrutiny as the constitutional standard. It shields lawful defenders from civil destruction. It makes individual officers personally accountable for rights violations. It demolishes the sensitive place loophole. It ends bureaucratic delay as a substitute for constitutional compliance. It strikes down storage laws designed to render rights useless. It exposes and orders destroyed the illegal registries that weren't supposed to exist. It stops regulatory weaponization against compliant gun businesses. It ends the patchwork carry reciprocity nightmare. It shifts home defense prosecutorial burden where it belongs. 10 changes. One coherent dismantling of a coherent strategy that has been suppressing constitutional rights for a generation. And the officials who built that strategy, who enforced it, who defended it in court, they are right now, in February 2026, trying to find the next workaround. They are looking for the next loophole, the next creative redefinition, the next bureaucratic mechanism that achieves what direct prohibition cannot. Your job, and I mean this seriously, is to stay informed enough that the next workaround gets the same treatment this one just got. Drop a comment right now telling me your state and which of these 10 changes hits closest to home for you personally. Tell me which of these injustices you have lived with, which one you didn't know you had recourse against until right now. Share this with every gun owner in your life because these protections exist in the law, but they only protect people who know they exist. Subscribe with notifications on, because this legal landscape is moving fast in 2026, and you need reporting that keeps up with it in plain language. Not legal jargon, not partisan spin, but the truth about what your rights are and what is being done to protect or undermine them. The fight for constitutional rights in America is never finished, but right now, in this moment, the momentum is undeniable, and you need to be in it, informed, and ready.